Right, well, welcome everyone to the third in this series of Doughty Street Clinneg PI team lockdown webinars. If you have missed either or both of the first of them on respectively Conneg in RTA cases and vicarious liability under the recent Supreme Court decisions, or you'd like to review this one or future webinars, the recordings will be available on request to the clerks. So please do get in touch if you'd like the links. We are very glad to have you join and would very much like to hear your feedback and suggestions for future webinars that you think we can usefully offer. So today it's the chance of the employers' liability lawyers to have their say. But also we'd like to engage with you if we can. There's an opportunity to ask questions. If you do have a question, please type it in when you think of it via the Q&A button or icon, which you should find on the menu bar at the bottom of your computer screen or the top right of your iPad or phone, and we will try to get through as many of those as we can at the end. Now, if I just move on to talk to you briefly about the structure of the webinar, what we will intend to cover today, I'm going to deal with the introductory remarks in a little detail, and then I will hand over to Chris and Freddie respectively to deal with some examples that we thought might illustrate the issues and be of help to you. So next slide, please. So the general context for this discussion is the structure of health and safety protective provisions that we can trace back to the early part of the 19th century, the Health and Morals of Apprentices Act in 1802, and then a series of acts following on from that, latterly becoming increasingly called the Factories Act and dealing with factories, dangerous places obviously, running up to 1961. And then afterwards, probably the next milestone was the Health and Safety at Work Act in 1974. That remains the overarching structure for regulatory provision protecting of workers in this country. And then we had in 1992, effective from 1993, the six-pack regulations as they're known, the Management of Health and Safety at Work regulations, etc. And they brought in what was perceived generally to be a wholly new approach, a proactive assessment approach based very much on risk assessment, more of that later, casting upon employers the obligation to think in advance about risks which might arise rather than reacting to problems that occurred in the workplace. And then on that last bullet point, I've added the word Brexit, the dreaded word Brexit, which we've almost forgotten about now, partly because I've been asked, or was asked by the editors of the Journal of Personal Injury Law to do a piece on how Brexit was likely to affect employers' liability law, and that's to be published next week, I think. The broad summary is not much immediately, because by combination of new regulations and transitional provisions dealing with the current transition period, which is due at the moment to end at the end of this year, the law is largely retained in its current form. The big issue with Brexit will be what happens after that. How, if at all, will the protective mechanisms of the current health and safety law be reduced or allowed to stagnate, if I can put it that way. But we will just have to wait and see. Now, there's a lot of very well-established law, therefore, in the area of health and safety and employers' liability. You'll notice that quite a lot of the cases aren't very recent. I'm trying to mention a few recent cases, but a lot of the cases go back some distance. Next slide, please. As far as contributory fault is concerned, the starting point was the old common law rule that contributory negligence was a complete defence because of the so-called doctrine of common employment. You find Lord Atkin of Donahue and Stevenson fame explaining it briefly in summary here in Caswell. The injury may be the result of two causes operating at the same time, a breach of duty by the defendant and omission on the part of the plaintiff to use the ordinary care for the protection of himself or his property that is used by the ordinary reasonable man in those circumstances. And in that case, the plaintiff cannot recover because the injury is partly caused by what is imputed to him as his own default. Next slide, please. Well, that had to go, and it did go in 1945 with Section 1 of the Law Reform Contributory Negligence Act. Now, this is a general provision. It doesn't just obviously affect employer's liability, but its importance in this context is it becomes the only rules affecting the allocation of contributory fault in the employer's liability situation, because at common law, there was no contributory fault, there was just a complete defence. But the provision is worth reading. Where any person suffers damage as the result partly of his own fault and partly of the fault of any other person or persons, a claim in respect of that damage shall not be defeated by reason of the fault of the person suffering the damage, but the damages recoverable in respect thereof shall be reduced to such extent as the court thinks, this is my emphasis, just and equitable, having regard to the claimant's share and responsibility for the damage. And that add-on of just and equitable allows, therefore, acts or omissions on the part of the claimant that would ordinarily be considered negligent in a third party, for example, signing in damages, such as by way of a momentary inadvertence by a driver in a road traffic situation, to be excused by way of there being no deduction for contributory fault. Next slide, please. And so what we have to do is we have to approach it as a way of balancing of culpability of the parties respectively, bearing in mind their respective positions and obligations. And various obvious questions are raised in the employment context. Firstly, had the employer taken adequate measures to bring any safety practice instructions to the employee's notice and ensure that he or she complied? What was the workman's knowledge and experience? Was he or she properly instructed? What was the nature of the workplace? Was it a calm place? Was it full of distractions? All of these things come into play. In Reeves and the Metropolitan Police Commissioner, Lord Hope pointed out that one, as he put it, one should not be unduly inhibited by the use of the word negligence in the expression contributory negligence. And it's worth noting that the words negligence don't appear in Section 1 itself at all, although the Act has the words contributory negligence in its title. But the assumption developed that fault in this context means the same as negligence, and the very name of the partial defence, contributory negligence, does not help to avoid that. A reduction under the Act, though, involves the finding that it is just and equitable for the claimant's fault to result in a reduction. That's not the same thing as a finding that because the claimant's actions or omissions show him or her to have been careless or negligent, that there should therefore be a reduction. So tripping over a box, for example, that was there to be seen on the floor in front of the claimant, had he or she bothered to look down, is likely to be negligent. However, it will not always justify an equitable reduction. Above all, a finding of contrib depends on a comparison of the faults of the claimant and defendant, as I've said, and it is particularly important, therefore, in the context of cases in which primary liability is admitted, that sufficient evidence is obtained or produced to show just how reckless or bad or egregious the defendant's conduct has been. So where liability is admitted, you're still going to need evidence on behalf of the claimant to resist the con neg defence by highlighting the actions of the defendant, not just focusing on the actions of the claimant. Then there's the question of whether there's a cap, whether you can have 100% contributory fault, for example, under Section 1. Well, there are different opinions about this. In Pitts and Hunt, Lord Justice Beldam in 1991 said that Section 1 begins with the premise that the person suffers damage as a result partly of his own fault and partly of the fault of any other person or persons. Thus, before the section comes into any operation, the court must be satisfied that there is fault on the part of both parties, which has caused together the damage. It's expressly provided the claim should not be defeated by reason of the fault of the person suffering the damage. To hold that he or she is himself entirely responsible for the damage effectively defeats the claim. It's then provided that the damage is recoverable in respect thereof, that is, the damage suffered partly as a result of his own fault and partly the fault of another person, shall be reduced. So that presupposes that the person suffering the damage would receive some damages. Finally, reduction is to be to such extent that the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. To hold that the claimant is 100% responsible is not to hold, what Justice Beldam said, that he shared in the responsibility for the damage. Well, there you have it. I'll come back to that in a bit later. Next slide, please. You'll gather I am, next slide, please. I am concentrating on dicta from courts, from senior judges in the senior courts. I think it's important to do that. Then we have the famous case of general cleaning contractors in Christmas, where Lord Oaksey made the perhaps obvious point, but important point, that it is well known to employers that in their work, people are very frequently, if not habitually, careless about the risks their work may involve. And indeed, this is the very point of the regulatory protective structures, to protect workers in part against their own carelessness. The worker is, under Section 1, not automatically to be punished, as it were, for his or her careless, even reckless behavior. Next slide, please. So a couple of technical points. Firstly, the contributory fault defense is to be pleaded and proved by the defendant. In Genick and CTO, a finding of contributory fault was set aside by the Court of Appeal, as the judge had based that finding on an allegation of negligence that hadn't been pleaded or even argued at trial properly. Lord Justice Judge, who was then president of the QB, said the decision on contributory negligence is not based on a mere pleading point, nor can it be dismissed as an unmeritorious problem arising from legal technicality. A much more important principle is involved. As a matter of simple justice, and like any litigant in civil proceedings, the claimant was entitled to know of any misconduct, including negligence, alleged against him, and to be provided with a proper opportunity to enable him to deal directly with and answer the allegation. Then there's the point that fault negligence on the part of the claimant requires there to have been foreseeability of harm. Now, as far as something properly called negligence is concerned, that would be obvious that there must be a harm that was foreseeable to the claimant in breaching his own duty to himself, if you like. But even if the fault is of a different kind, not constituting negligence as such, my contention is it certainly wouldn't be just inequitable to reduce the damages of a claimant if the harm which resulted from his own failing, his or her own failing, was not foreseeable to him or reasonably foreseeable in general. Now, in Jones and Liebox, Lord Denning said, although contributory negligence does not depend on a duty of care, it does depend on foreseeability. Just as actionable negligence requires the foreseeability of harm to others, so contributory negligence requires the foreseeability of harm to oneself. A person is guilty of contributory negligence if he ought reasonably to have foreseen that, if he did not act as a reasonable, prudent man, he might hurt himself, and in his reckonings, he must take into account the possibility of others being careless. But in the same case, it was apparent that it's not necessarily the case that you have to foresee, as the claimant, the precise manner in which the injury will occur, or for that matter, its full extent. And again, Lord Justice Singleton in Jones said, in so doing, looking at the facts of that case, in so doing, he, the claimant, was exposing himself to danger. It may well be the chief danger was that he might fall off or be thrown off, or that he might become entangled in some part of the machine on which he was riding. And then this, but those were not the only risks to which he subjected himself, and it was one of those risks which eventuated. So it's sort of wagon mound principle application, that you have to foresee the type of damage, but not necessarily its precise mechanism of occurring or its extent. And then in Westwood, the facts briefly of that were the man fell through a hole or door in a room into which entry had been prohibited by the employer. But the notice prohibiting entry had contained no warning of danger. There was no suggestion there was a danger in the room into which you go through the door. So the House of Lords held in that case that disobedience to orders in itself was not negligent, without the claimant being able to foresee that he might be taking a risk with his own health and safety. There was no basis for the reduction on the basis of contributory fault. And then the fault on the part of the claimant has to be causative. In Toole and Bolton MBC, the employee had failed to heed a note that he should use heavy-duty gloves when picking up litter, and he sustained a needle stick injury. But the crucial fact was that the gloves made available by the employer would not have prevented that injury. So the Court of Appeal held that there was no contributory fault no relevant contributory negligence in those circumstances. Next slide, please. So I'm coming to the question of how bad and how much. How bad must the claimant's conduct be to merit a deduction, and what should that deduction be? But in general, it's right to point out that the assessment by the court has to be, will often have to be, a really quite broad one. In Jackson and Murray, in the Supreme Court in 2015, our current president, Lord Reid, quoted his predecessor, differently spelt Lord Reid, in Stapley and Gypsum Mines, and said, a court must deal broadly with the problem of apportionment, and in considering what is just and equitable, must have regard to the blameworthiness of each party, but the claimant's share and responsibility for the damage cannot, I think, be assessed without considering the relative importance of his acts in causing the damage apart from his blameworthiness. So there are two aspects to the assessment process. One is, if you like, the moral or moral culpability, blameworthiness in general terms. And the other is the causative potency of the failing on the part of the employer on the one hand and the employee on the other. And both of those aspects need to be taken into account by the court in balancing the faults in order to reach a just determination. Next slide, please. So how bad and how much? Well, it's our proposition that one can, as a general rule, work on the basis that in an employer's liability case, the maximum deduction for contributory fault should ordinarily be considered to be in the range 50 to 75%. And in fact, I'd go further and say ordinarily 50% is enough. And it really is an exceptional case where something as high as 75% would be required. Although there's a dispute about whether 100% finding is possible, they're unheard of in reality. And for the reasons that I've mentioned in the judgment from Lord Justice Sadley. But if I go back to that judgment, Toole and Bolton, sorry, Lord Justice Buxton, in Toole and Bolton, that's the case about the needle stick injury with the gloves. In that case, the recorder had made a finding of primary liability, but reduced Mr. Toole's damages by 75% for contributory fault. But the Court of Appeal interfered and substituted a full liability judgment. But there was the point about whether the gloves would have worked in any event, of course, and it was found that they wouldn't have worked, the gloves that were offered. But also, Lord Justice Buxton made these observations. He said, I approached the question of whether a finding of contributory negligence should have been made in this case at all from a background of principle. It is not unusual for there to be marked findings of contributory negligence in a breach of statute. Sorry, it is not usual for there to be marked findings of contributory negligence in a breach of statutory duty case. And it is, I'm bound to say, in my experience, very unusual indeed for there to be a finding of contributory negligence at the level of 75%. If in a statutory duty case the judge finds himself driven in that direction, he should, in my judgment, seriously consider whether he is not in fact finding that there's been no causal connection at all between the breach of statutory duty of the employer and the injury. And he finished with, I fear I do not start to see how an employee can be said to be contributorily negligent when he fails to take a precaution, the wearing of the ineffective gloves, asserted by the employer, but that precaution itself consists of and contains the breach that the recorder has already found. Simply as a matter of logic, I do not think the finding that the recorder made as to contributory fault was open to him on the facts that he found. So that's a pretty bold approach, which obviously for claimant one would adopt. And it points to the conclusion that once you get to findings of contributory fault of 75% or more, then you're really talking about no causation at all from the employer's breach. In the Anderson case, the claimant had been found 90% contributorily at fault in a case where he had, to be fair, been blatantly reckless. But that was the appeal in that case was allowed as well, and the amount of deduction was reduced to 50%. In that case, Lord Justice Sedley held that to escape a breach of statutory duty, the defendant had to establish that the claimant was wholly to blame and that the defendant had done all that was reasonable to ensure compliance. So piling requirement upon requirement there. Now, it's right to say, as I think I mentioned, that this isn't completely without controversy. In Scotland, the view in Anderson that 100% contrib wasn't really possible was not accepted by Lord Emsley in the Outer House in McEwen. Now, I'm keen to quote Scottish cases because, frankly, quite a lot of the authority in the area of employers' liability has often come from the Scottish decisions all the way up to the House of Lords Supreme Court. So it's always worth looking at how the matters are dealt with in Scotland. And in McEwen, Lord Emsley, as I say, rejected the proposition that 100% contrib isn't possible. And he considered in particular that it conflicted with another decision of the English Court of Appeal in Jays and IMI. And he preferred that case and he followed it. He said it was an eminent court. That's pointed, obviously, but he may have had a point because that court consisted of, or included Sir John Donaldson, Master of the Rolls, and one Lord Justice Robert Gough, who went on to be the very eminent Lord Gough. So I suppose you take your pick between these supposedly conflicting authorities. But even so, having decided that he didn't accept that argument was right, he stopped short in that case. And it was a case where he held that the pursuer had in fact spilt the very oil that he slipped on. But the judge stopped short of a finding of 100% contrib and found a contrib of 75%, which I would say is sort of supporting the contention that we make, that you can treat 75% as a rough maximum, absolute maximum, even in the most stupid of cases, if I can put it that way. And then in Egan's a case which illustrates the required weighing of relative blameworthiness in a case where the defendant was in breach of Regulation 4 of the Manual Handling Regs. The claimant was a nurse and she had herself failed to ensure that the forks of the hoist that she was operating were sufficiently under the bath in which the patient was. Now, the Court of Appeal found the claimant was 50% to blame for her injury. Lady Justice Smith, who wasn't known to be anti-claimant, said, "I find myself unable to distinguish between the two parties when considering blameworthiness. It seems to me neither side could or should be heavily criticised, note that. Accordingly, I find myself driven to conclude they should bear the responsibility equally." Now, that's considered by some to be a very harsh assessment of the claimant's degree of fault under Section 1, when it's remembered that the defendant was in breach of a very strict statutory duty and that the principles surrounding whether mere inadvertence should constitute negligence in those earlier senior authorities applied with some force, one might think. If neither side could or should be heavily criticised, but the defendant was in breach of statutory duty, then arguably the claim had to succeed. If no sufficient fault could be shown by the defendant to justify a case for a reduction of any amount, let alone 50% reduction, arguably the claimant ought to have succeeded in full on the just and equitable ground. Now, this may be the sort of case where the removal of strict liability in regulatory cases by Section 69 of the Enterprise Act 2013 may come into play. I'll say a bit more about that in a minute. And then Walsh and CP Hart, Mr. Justice Martin Spencer, this is a very recent case, but what you need to bear in mind about this case was this is a successful appeal on liability by the claimant. The judge had erred, Mr. Justice Spencer found, in dismissing a claim for damages brought by an employee against his employer in respect of injuries he suffered when he fell from the back of a works vehicle. A risk assessment had been undertaken and it had identified the risk of fall injuries, and the employer had failed to take any reasonably practical measures to mitigate that risk. Contributory negligence was assessed at 50%. The claimant, the judge said, had lowered the tail lift and was aware that it was in the lower position and should have been aware that there was therefore a drop from the back of the vehicle. And then finally in this section, the Wallace case, another Scottish case, not without its amusement. In order as a matter of courtesy to others to ventilate the staff toilet cubicle, the 5'1" claimant school clerical assistant had to stand on the toilet bowl to open the window. Sadly, the toilet collapsed. Sadly, but perhaps predictably, the toilet collapsed and she was injured. The evidence showed this was the known practice of her and colleagues, but the Lord Ordinary held that the local authority had not breached its statutory obligations despite there being no risk assessment under Reg 3 and an apparent breach of Reg 15 in that the opening and closing of windows and ventilators wasn't able to be done safely. There was no safe position of access and so on. But the judge said that it could not be held to be likely that the window would be opened by persons standing on the toilet bowl in order to reach it. He further held that had liability been established, damages would have been reduced by 50% on account of the claimant's contributory fault. Well, the appeal to the inner house succeeded on liability. Clearly, they said a risk assessment ought to have revealed exactly the risk, and Regulation 15 was clearly breached. The consideration of contributory fault was very brief and without citation of any authority. I read paragraph 22 in its entirety. As to contributory negligence, we are, however, in full agreement with the Lord Ordinary. As he said at paragraph 24 of his opinion, this was not a case of momentary inattention or inadvertence. It was a deliberate act by the reclaimer, which she acknowledged in her evidence to have been dangerous. That was obviously important, and which she had done on an unspecified number of previous occasions. It appears to us that a reduction of any award to the reclaimer by 50%, as the Lord Ordinary suggested, is wholly appropriate. Well, there it is. One might say that must be open to question if you look at the reasoning of the Court of Appeal in Toole, a court which looked at the background authority in some detail. But perhaps this case reveals the danger of, if you like, the sop to the losing respondent in an appeal, where the appellate court might be minded to, quote, give something, close quote, to the defeated respondent. But it's perhaps difficult to see any real logical basis for the difference of approach in cases like Toole on the one hand and Wallace on the other. And I would suggest that part of the answer to this is not to allow the court to engage in a sort of an approach of assessment without reference to the considerable amounts of authority about the approach that should be taken. So where do we get to? Well, the normal maximum, I still say, should be considered to be about 50%, and in a really, really bad case for the claimant, maybe 75%. But that should be considered, I would suggest, to be the effective absolute maximum. Now, on the other side of things, we have the minimum levels. We've offered a range of 10 to 20%. If you look at Butcher, another case where Lord Justice Sedley gave one of the leading judgments, he said that 10% is so nearly a token figure that one's first reaction is that it betokens an absence of significant fault on the claimant's part, so that it wouldn't obviously be just unequitable to reduce the claimant's damages in those circumstances. In Cooper and Carillion, which we mentioned earlier, there was a successful appeal against the finding of 10% contributory negligence on a similar basis. Somers is a good example of just how bad it can get for the claimant, and yet there not be a significant reduction of, in this case, his damages. Mr. Somers was found, I put in parenthesis only, 20% contributory at fault, towards the bottom end of the possible scales. The bullet points of the facts are: he was cleaning a mixing machine which started to operate. His arm was amputated. He had not used the machine in the way he'd been shown to use it. He had overridden a protective interlock, which he knew was there to prevent access to moving parts in the machine. He would have been able to clean the machine without it starting, whilst it was stationary. And although he didn't regard the slow-moving arm of the machine as dangerous, he knew that it would at some stage speed up. All hail Simon Hawksworth for keeping it to 20% in those circumstances. But you'll see there's a lot to play for, and as I've already said, a lot of senior judicial authority on the claimant side, but it needs to be cited. Next slide, please. So a couple more slides from me. Firstly, the Section 69 of the Enterprise, etc. Act, which we call ERA 2013, which, as you, I hope, realize, has the general effect, or generally considered to have the effect, of imposing an overall negligence requirement in order to condemn a defendant employer for breach of statutory duties in the employment law, employment liability context. Not necessarily quite as simple as that, but that's just a rough generalization about it. You will see a consideration of that by Jeremy Johnson QC here in Chisholm in 2018, where he said, "I do not consider that it is particularly relevant that liability results from breaches of a common law duty rather than a statutory duty. As it happens, Hankins were also in breach of statutory duties, It's just that those breaches do not directly give rise to liability and damages. More importantly, however, the duties that were breached were duties which were designed to prevent the very thing that occurred, namely momentary inattention on the part of a normally hardworking and attentive employee. This is not a case where the employee has consciously accepted a risk. And that is the way that I would suggest one should approach the effect of Section 69. The regulatory structures are still there. And although there's really no senior authority on this, I suppose you could say it cuts both ways, because if now the employer can only be liable in circumstances where, if you like, actual fault is to be found, rather than strict liability in the case of Stark and the post office, where the defect in the bicycle wasn't known to the otherwise well-operating, well-maintaining employer, the post office, and couldn't reasonably have been foreseen. Nevertheless, they were liable to Mr. Stark because there was a defect in the bicycle. But that wouldn't happen now, because there'd have to be a failure to take reasonable steps in light of a reasonably perceived risk, which didn't arise. But the other side of that, of course, is that now there always will be actual fault on the part of the employer, and that works against the employer in the balancing exercise, one might think. But the general point is the one that Jeremy Johnson was making in the Chisholm case, which is the regulatory structure is still there, and the employer is still liable criminally for failure to comply with the regulations. So it's difficult to see why, in terms of balancing faults, the same considerations don't apply, and on the other side, the same considerations must apply to the obvious point that it'll be sometimes difficult for the employee to be always taking appropriate care for his or her health and safety. So, last slide from me, please. Oh, I think it's the one before. Should be. Yeah. I come to the question of risk assessment, which I would suggest is crucial, and it derives, of course, principally from the six-pack regulations. A lot of these authorities go back a lot further beyond that, beyond 1993, but the whole idea that, you know, the obligations on the employer, primary obligations on the employer to protect the employees, and therefore one should be slow to blame the employees for what might otherwise be perceived as fault on their part, is surely added to by the fact that the whole new approach since 1993 has been the additional obligation on the employer to assess fully all the risks to people in the workplace and to take the responsible actions to minimize or avoid those risks. So when you come to balance of blame questions, as I call them, they're all ones which should be dealt with in a risk assessment, a properly conducted risk assessment. What are the risks? What are the aptitudes of the employees to avoid the risks, guard themselves? What training is required for the employees? What equipment do they need? Well, how can it be made safe? What personal protective equipment is required? And all of those considerations are intended to provide what Lady Justice Smith and Allison called a blueprint for action on the part of the employer, proactive blueprint for action, blueprint for proactive action. I suppose that's obvious. And that was adopted, as it were, hook, line and sinker, by the Supreme Court in Kennedy and Cordia, a case about a care assistant slipping on snow and ice, where the courts below had found against her, and the Supreme Court very much found for her, on the basis that there hadn't been proper risk assessment, and had there been proper risk assessment, she could have been protected. So the whole balancing exercise is crucially affected by the presence or absence of a proper risk assessment. And that really should be your starting point in addressing where a balance of fault should be considered to lie. So those are the points I wanted to make by way of opening and introduction. So now, if I may, I'll pass on to one of Freddie or Chris, who are going to deal with some examples for you. Thank you.
Moving to me, Theo. The topic I'm going to deal with is contributory negligence in cases of obvious risk. From finishing my GCSEs until I finished at university, I worked each summer at a factory near where I grew up. While I was working there, I did various things to make my life easier that I knew I shouldn't be doing. Two particular examples stick in my memory. The first was always using the nail gun where the safety trigger had been disabled. The second was that when I'd spent the day painting, I would use industrial solvents meant for cleaning tools to clean my hands, ignoring warning signs and thick rubber gloves that were supposed to be worn when handling the solvents. I could put it down to naivety and to following the bad example set by those around me, but the reality is that I was knowingly taking an obvious risk. If I'd been injured and established primary liability against my employer, to what extent would my damages have been reduced for contributory negligence? Theo has set out the principles, which, to recap, are that damages may be reduced for contributory negligence where the claimant's own fault has contributed to his injury, that the extent to which damages will be reduced is to be calculated taking account of both relative fault and relative causative potency, and that where the claimant has taken an obvious risk, his relative fault will be greater and the reduction for contributory negligence will be higher. As I said, Theo set out the principles in some detail. In my part of this presentation, I'm going to go through 3 cases to illustrate how those principles are applied by the courts. The idea is to put the principles into context, to illustrate the kind of behaviour from claimants that may attract certain levels of reduction. Next slide, please, Freddie. The first case is Quintas and National Smelting Co Limited. In this case, the claimant's actions were described by the Court of Appeal as, to quote, amazingly foolish. The facts of Quintas were as follows. The claimant was employed as a fitter at the defendant's factory. In the factory, there was what was described as an overhead ropeway. It was a pulley system by which buckets suspended from a line travelled through the factory, depositing their contents where required. Throughout the day, the overhead ropeway would stop and start without warning. On the day of the accident, the claimant was working on the flat roof of the Magnet House, a building within the factory. The overhead ropeway passed only 4 foot above the roof of the Magnet House. The claimant had finished his work and was waiting to be relieved by a colleague. He walked to the edge of the flat roof to shout to someone below. At this point, the overhead ropeway was stationary, but the claimant was stood adjacent to a stationary bucket and directly in the path of the overhead ropeway. The ropeway started, the bucket struck the claimant who was knocked off the roof, sustaining injuries. Next slide. The Court of Appeal held that the defendant was in breach of its common law obligations. Turning to contributory negligence, Lord Justice Dankworth stated, of course, the plaintiff behaved in an amazingly foolish manner, turning his back on the buckets and standing directly in their track when a step or two to one side would have avoided danger. The plaintiff admitted in his evidence that he knew where the track of the buckets went across the roof, but I think he chose to stand where he did because he assumed that the ropeway would not be set in motion before he had dispatched his message to the foreman. It is not easy to apportion the blame in such a case, and on the whole, I'm prepared to accept the view of Lord Justice Sellers that 50% reduction of contributory negligence is sufficient. This claimant knowingly stood in the path of the overhead ropeway. This was described as amazingly foolish, and yet the reduction was only 50%. Next slide, please. The second case is a case called Udin and Associated Portland Cement Manufacturers Limited. In Udin, the trial judge had described the claimant's act as one of extreme folly, outside the reasonable anticipation of a prudent employer. The facts of Udin were as follows. The claimant was employed at the defendant's cement factory. Some pigeons lived in the roof of the factory. Some of the employees had contributed to a fund to buy corn for the pigeons, but the claimant was not one of them. He'd refused to contribute to the fund. On the day in question, the claimant was stalking a pigeon through the factory. The trial judge had concluded that, to quote, whatever were his designs towards the pigeon which he was stalking, they were not actuated by benevolence. The claimant climbed up a ladder and onto a platform. He was in an area of the factory that he was not authorised to be in. In an attempt to grab the pigeon, the claimant leaned out from over the side of the platform. His sleeve became entangled in a rotating shaft and his arm was removed. Next slide, please. The defendant was primarily liable for breaches of various provisions of the Factories Act. The trial judge reduced the claimant's damages by 80% for contributory negligence and the Court of Appeal declined to interfere. Lord Pearce said, on the one hand, the plaintiff was guilty of extreme folly outside any reasonable anticipation and was doing an unauthorised act in an unauthorised place for his own purposes. No accident had previously occurred, and but for the plaintiff's foolish and unauthorised act, this accident would never have happened. On the other hand, the defendants, who should have known better, failed to carry out their statutory obligation to fence. It was not a bad failure, but without their failure to fence, this accident could never have happened. The plaintiff was a foreigner who may not have had industrial experience before he came to this country. His unintelligibility may have led the judge to think that there were reasons which would palliate his folly, though they could not excuse it. And in any event, the judge's proportion leaves on the plaintiff's shoulders far the greater weight of a large load of damage. The problem of contributory fault is difficult and peculiarly within the province of a trial judge, and he cannot hope that everybody would form the same assessment as he does himself. In my opinion, the judge could have found the percentage to be higher. His assessment inclined towards the bracket most favourable to the plaintiff. He was within the brackets between which reasonable assessments could range. This case, where the claimant was injured whilst chasing a pigeon through unauthorised areas of the defendant's factory, shows the type of truly foolhardy behaviour that's required to justify a reduction of 8%. However, despite the recklessness of the claimants in Udin, my view, and having discussed the case with them, the view of Theo and Freddie too, is that the 80% reduction is high. We note that in Udin there was no citation or analysis of Section 1 of the 1945 Act, and we note that there was only a single contributory negligence case cited in argument. Next slide, please. The third case is called Clifford and Charles H. Callan and Son Limited. The facts of Clifford were as follows. The claimant was employed in the defendant's factory. The claimant regularly used synthetic glue. The synthetic glue posed a risk of dermatitis, which would be reduced if a barrier cream was used when handling the glue. The claimant knew of the risk of dermatitis. He knew that he should use barrier cream. He knew where the barrier cream was kept, but because it was kept in the store and not in the shop, the claimant neglected to use it. The claimant developed dermatitis and claimed damages. The Court of Appeal held that the defendant was primarily liable for failing to provide barrier cream in the shop. The claimant's damages were reduced by 50% because he knowingly took an obvious risk. To conclude my contribution to this webinar, the purpose of considering the facts of these three cases in detail was to put the principles discussed by Theo into some context. And I hope that I've illustrated the following points. The first is that the level of reduction for contributory negligence will depend on the particular facts. The second is that even where a claimant knowingly takes an obvious risk, the reduction does not have to be 60, 70 or 80%. And third, that to justify such a high reduction, the behaviour of the claimant must be truly foolhardy, such as chasing a pigeon through unauthorised areas of a factory. That concludes my part of the talk, and I'll hand over to Freddie.
Thanks, Chris. I'm going to talk about contributory negligence in the context of personal protective equipment. And the paradigm case where this is relevant is where a worker is issued with an item of personal protective equipment. They decide not to wear the equipment, and they are then injured as a result of the failure to wear that. And in that case, a partial defence of contributory negligence may apply, subject to the caveats that Theo and Chris have been talking about. The duties imposed on employees regarding PPE are set out in legislation. No liability arises directly from a breach, but the legislation will be a convenient starting point for assessing whether an employee has been contributorily negligent. Looking at those regulations, Section 7 of the Health and Safety at Work Act 1974 imposes a duty on employees, firstly, to take reasonable care for the safety of themselves and other people affected by their acts or omissions at work. And secondly, to cooperate with employers and others in carrying out the duties imposed upon their employers and others. The Management of Health and Safety at Work Regulations 99, Regulation 14 imposes a duty on employees firstly, to use equipment in accordance with training and instructions given by the employer, and secondly, to report serious and immediate dangers to health and safety. The Manual Handling Operations Regulations, Regulation 1992, Regulation 5, imposes a duty on employees to make full and proper use of any system of work provided by the employer under the regulations. And lastly, the Personal Protective Equipment at Work Regulations 1992, Regulation 10, subsection 2, provides that every employee shall use any personal protective equipment provided. The issue of contributory negligence in respect of the Personal Protective Equipment at Work Regulations of 1992 was considered in the case of Henze Leather against Securicor Cash Services Limited. And in that case, the defendant security firm had breached its common law duty of care together with the Personal Protective Equipment at Work Regulations by failing to make sure that suitable body armor was provided to its security guards and to make sure that appropriate arrangements were made to ensure that it was worn. And Lord Justice Kennedy rejected the defendant's contention that the claimant was contributorily negligent, as he might not have worn the PPE in breach of Regulation 10.2. And he said the defendant took no steps to comply with the PPE regulations. So it is, in my judgment, impossible to contend that the claimant would not have complied with his obligations under Regulation 10.2 had the body armor been supplied and had those steps been taken. Henze indicates, in our view, that the courts will not entertain contributory negligence arguments that are essentially speculating on what the employee might have done if the employer had not breached its duty. In Ashbridge against Christian Salverson, a Scottish case, the claimant was a supervisor who was attempting to drain down a tank, and he wrongly assumed that the tank was empty. He opened the door and the caustic solution poured out and he suffered burns on his feet. He succeeded in establishing breaches of the provision and use work equipment regulations and the PPE regulations and liability at common law. However, despite proving primary liability, he was found to be, quote, cavalier in the extreme in his attitude towards checking the level of the tank before opening the door. And Lord Glennie said that he displayed the most wanton disregard for his own safety, although that did not absolve the defendant from responsibility for the inadequacies of the system. Lord Glennie also rejected the submission from the defendant that the claimant should be found to be 90% contributorily negligent and found instead 50%. And Ashbridge is a good example, in our view, of the point that Theo's made, that the courts are reluctant to make considerable deductions for contributory negligence, even where a worker has been careless, even reckless. In terms of a few points to make about PPE in the context of noise-induced hearing loss claims. The defendant will frequently allege in these claims, often at the pleading stage, that the claimant has elected not to use the earplugs that were provided to them at a time when they could have done so. And it's important, we say, to interrogate the causes for the alleged non-use of the equipment. This is a point that applies not just in noise-induced hearing loss claims, but more generally. Often, the employee will not have received appropriate training regarding their use, such that they'll not be in a position to appreciate the risks of, for example, excessive noise exposure and the need to wear hearing protection. A classic example of this is the fact that people might think it's appropriate to wear hearing protection when it's noisy, without realizing that chronic exposure is also problematic. In terms of supervision, it's worth asking the question whether there was supervision of employees to ensure that they comply with the employer's instructions. And as Theo has said, the employer is responsible for taking reasonable steps to ensure that the employee complies with health and safety requirements. And thirdly, the employer may not have taken reasonable steps to make PPE available in practice in the right locations and quantities. And I've acted in cases where the employer has claimed that they've provided earplugs, for example, but what that amounted to was providing a small supply, which would be rapidly exhausted shortly after it was deposited. In terms of the Gibson case, and the point that I wanted to make about this was that Gibson was a case which shows that the court will analyse very carefully the benefits of the employee complying with the employer's health and safety regime before reaching a finding of contributory negligence. Gibson concerned the death of a man who fell from the top of an electricity pylon during his employment, and the deceased didn't wear the safety belt that he'd been provided with and told to wear. And the House of Lords held that there was no contributory negligence in failing to wear the safety belt, because even though the belt was capable of preventing the fall to the ground and potentially a fatality, it could in some circumstances cause a fall to the ground and might not prevent serious injury. And there's 2 points that we would draw out of Gibson. The first is that the mere act of disobeying instructions does not mean that a court would find A, that an employee acted unreasonably, or B, that their conduct was such that it was just and equitable to reduce their award in damages. And secondly, Gibson, we say, is still likely to be relevant in the context of a failure to use unsuitable work equipment under Regulation 4 of the Provision and Use at Work Equipment Regulations. Briefly, we've considered the issue of PPE and COVID-19 in an article that we've, Theo, Nick Brown, and myself have written about this regarding potential claims arising from failures to provide PPE equipment to frontline care staff. The next scenario I want to talk about briefly is rescuers, because we've been asked to consider whether an employer can be liable to persons other than employees, and to what extent damages may be reduced by finding of contributory negligence. One situation arises in respect of rescuers, where an employer by negligence creates a situation which puts other people in danger. They owe a duty of care to those whom they ought reasonably to foresee may hasten to the rescue at risk to their own safety. And it should be noted that these are different situations with different bases of liability on the defendant, but the comparisons are interesting because they share some features, and they could both arise because health and safety regulations cast liability both on employers for their own employees, but also on third parties present within the workplace. A good example of this is the case of Baker against T.E. Hopkins and Son. And in Baker, there were 2 employees of the defendant company were overcome by carbon monoxide fumes in a well that they were attempting to decontaminate. And the fumes had been caused by the negligence of the defendant. The claimant was a doctor, and he went in to try and rescue the men at the bottom of the well, even though he'd been warned of the fumes and he'd been told that the fire brigade were on their way. All 3 men died as a result. And Lord Justice Morris said that it was possible in limited situations for a rescuer to be negligent if they act with, quote, wanton disregard for their own safety. The point was echoed by Wilmer L.J., Lord Justice Wilmer in Baker, and he also noted that the burden of proof is on the defendants in these cases, and that the conduct would have to be so foolhardy as to amount to unreasonable disregard for his own safety. And there's 2 points that we seek to draw out of these cases. The first is that an employer is deemed liable for creating, where an employer is deemed liable for creating a risk that leads to an employee or someone who is not an employee, such as a paramedic or a worker, taking a risk to avoid or reduce the hazard that the employer has created. The courts are going to be slow to find that the employee or the rescuer was contributorily negligent. And secondly, we say that the starting point in these cases regarding any allegation of contributory negligence will be favourable to the claimant, who is confronted by a risk for which they are arguably not at fault. So I'm now going to hand you back to Theo and Chris to deal with some questions that you may have.
Thank you very much, Freddie. You say that, but I can't at the moment. I've got the Q&A protocol open, but I don't think there are any questions unless you can see some questions that I can't. So
I can't see any questions. I think we must have been so thorough.
We've covered it, ladies and gentlemen. Obviously, we've just covered it, so that's all good. But if anyone does have any questions, fire them off now whilst I say thank you very much for... oh, we seem to have a question. Let's have a look. It's in chat rather than Q&A, but that doesn't matter. Let's have a look. One question. Hang on. Oh, here we go. Not sure if it's a question. Is it a question? What's your view on con-neg and clinical negligence? It's a little bit, Nathan's a little bit out with the topic that we're discussing today. I mean, I'm not going to say you can't have con-neg and clinical negligence cases. Of course, you can. Different considerations will apply, but the balancing exercise required by certainly Section 1 of the 1945 Act will still come into play. Obviously, very different considerations apply in relation to, for example, a patient who is dealing with their own health problems, as opposed to an employee who is required to do work by an employer in circumstances, as we're talking about, where the employer is in breach of duty to the employee to keep the place safe. So it's an interesting question, but probably one for another day, which I'm sure we'll get to in amongst our team, but not if you don't mind, not just at this moment. I can see a question here. Do you foresee a greater use of contributory negligence defence in future claims related to COVID-19? I suppose it very much depends on what sort of claim was made in relation to COVID-19 and how, you know, what the breach of the primary obligation alleged was. For example, just off the top of my head, and it's always dangerous to think about things off the top of your head, but as Freddie mentioned, we've recently done an article about PPE and essentially about the much criticised failure to provide PPE to mainly frontline clinical staff in the context of the pandemic, but it also applied to others such as those working in supermarkets or those driving public transport. Whether there's any scope for arguing contributory fault in running the risk of infection, I can't rule out the possibility, but it would be a harsh judge indeed who said that someone with a vocation to look after people had been contributory at fault, in the sense of it being just and equitable to reduce their damages where all they've done is carry on doing their job as they were on the face of it still being required to do. I'm not sure whether, Amalia, that's what you had in mind. But perhaps I can leave it there for now. If you want to follow up, if anybody wants to follow up with questions by email, we'd be happy to field those, of course. So do get in touch. I can see more questions appearing in the question Q&A section. I'm going to hand over to somebody else to answer a question in a minute. Let me see. What incidents can you see arising in relation to COVID-19 that fit into the 10 to 20 minimum category, and what incidents in the 50 to 75% category? I think, Hannah, you're getting into the realms of speculation. Just to adopt what I think it was Freddie said, it might have been Chris. You know, they're so fact dependent. The assessment, the balancing exercise is so fact dependent. You really have to look carefully at what the facts of a particular case are and what the aspects of fault that the court might find on the part of, on the one hand, the employer, and on the other hand of the employee. Chaps, do you have anything to add on that point?
No.
Nothing to add to that. I can see that a few people have asked for us to send out the link to the COVID paper, and perhaps we'll try and do that along with sending out the slides.
Yes, I could see. Yeah, happy to do that. And in fact, pleased to say that the editor of the New Law Journal has picked that up, and that's being published in tomorrow's New Law Journal. I think it's already up online, pretty much the same paper. I think well, I updated it slightly because it had been a couple of weeks since we put it on our Chamber's website, but you'll find an updated version published overnight, as it were, today and tomorrow by the New Law Journal. And then there's another question I can see. If a third-party insurer has advised that primary liability has been admitted, but they'll allege con-neg, what are the documents you would want to be seeking from them? Would you consider a pre-action disclosure application? As to the last, I mean, I'm not saying it's not possible, but on the other hand, might not be necessary, bearing in mind that it's the obligation of the employer to plead and prove the allegation, that in disclosure terms, in general, it would probably be safe to leave it to the ordinary processes of disclosure and the litigation. Obviously, that doesn't help you evaluate the strength of contrib allegation. On the other hand, it should be properly pleaded, so the defendant should tell you exactly why he, she, or it is contending that the claimant brought it up on him or herself. So that may be, so for example, you've always got Part 18 question procedure to interrogate that, or you could even apply to strike out the defense for want of particularity in the right case, I suppose. I mean, it's certainly true that one sees a lot of very vaguely pleaded contributory fault allegations by defendants, so there's plenty of scope to challenge them. But in terms of disclosure itself, my starting point would be it's probably safe to leave it to the process of litigation in the ordinary course. And then the other point was, what documents would you want to be seeking from them? Well, you know, again, for my part, it depends. It depends on the nature of the allegation. It depends on the factual matrix. It depends what's being said about the respective actions of the employer on the one hand and the employee on the other.
Theo, I mean, do you think it's helpful in those sorts of cases to see the same sorts of documents that one might rely on in order to prove a breach of duty or primary liability? Because I think as you pointed out earlier, that dynamic is relevant to the question of contributory negligence insofar as there is a balancing exercise that the court will have to conduct in trying to assess whether the employer and employee could have done more.
Absolutely, I agree, Freddie. And as you were saying that, I was rereading the question and reabsorbing that it's a case where primary liability has been admitted. So you fall into that very problem that I was identifying earlier. You get an admission of liability, they throw a contributory fault allegation at you, and you need to be careful that you are in a position to meet that allegation, including by disclosure, in relation to disclosure. But bearing in mind the duty is on the defendant, you know, if they don't disclose things which support their contentions against your claimant, they may be worse off. But obviously there may be material which supports the claimant's position, and it would be necessary to interrogate that position.
And just picking up on a question that you were addressing earlier, Theo, in terms of contributory negligence in the clinical negligence setting.
Yeah, I think avoiding is a better.
Well, avoiding it, which is it is something that I looked at relatively recently, and in essence, the courts are very reluctant to find.
We brought a lion into the room, by the way. Anyway, go on. Sorry.
They're reluctant to find that a patient has contributed to their injuries by their conduct. It could be said that there's an analogy in some sense between the employer and the doctor and the patient and the employee, but it seems to be the case, at least from my recollection, that the courts are even more reluctant to find that a patient should have or contributed to their injuries in a way that makes them culpable.
Sure. And of course, it will all depend on, I mean, it verges into issues of informed consent. It will all depend on what advice the person was being given and what options they were being given. But adopting any option that was given as a viable option in a treatment situation or for treatment, it would be difficult to see how the claimant could be condemned for any kind of contribution in those circumstances. And then it's quite difficult to see what else could be involved. I'm not saying that it can't be, but again, it all depends on what facts are being alleged before one can even begin to try to evaluate it. Good. I think we probably got to the end. It's 5:05. Not seeing. Is there any last question I'm missing? Don't think so. No. Right. Well, thank you very much for joining us today, everybody. Please don't forget, as I said, to contact the clerks if you would like the link to the recording of this or any of the other webinars in the series. And with that, on behalf of my staff, and I'm sure they can speak for themselves, but Chris and Freddie, I will say goodbye. Bye for now. Thank you very much.